So the number one question I get from folks who are unfamiliar with the Tennessee process is, how quickly may I foreclose? Tennessee is a non-judicial foreclosure state, and to foreclose, essentially, we file a document with the Register of Deeds office that appoints a lawyer in our firm as the new trustee under the deed of trust. We get a title search, and assuming that your lien is in the appropriate first position to foreclose, or that you have a subordinate lien that you've decided to foreclose, we draft a notice of foreclosure. We send it out to the borrower, all the guarantors and co-obligors on the obligation, any party with a lien or interest in the property, any tenants at the property. Send out the notice by certified mail, publish the notice in a newspaper 3 times, and bada boom, we can foreclose at the end of a 30-day period. So usually our holdup in doing a foreclosure, once we get the go-ahead to do it on a commercial side, obviously, as Katie and Brian discussed earlier, there are some additional holdups when you're dealing with residential cases, but on a commercial side, our holdup is generally waiting on appraisals and environmentals to come back for the lender so that they can be ready to foreclose. Seems, for the most part, the environmentals are taking a little longer right now. And so we generally can't start this process until we know you have that in hand, unless we want to go ahead and publish and then risk having to postpone the sale later on because, the bank doesn't have its ducks in a row to complete the foreclosure sale process. If there are title defects, missing or deficient loan documents, sometimes the location of the property and the existence of tax liens may cause the process to be delayed a little bit further. So since a borrower can't contest a complaint like they could in a judicial foreclosure, there are actually only 2 ways that the borrower can stop the foreclosure. One is there's a statute that allows a borrower to ask the court for an injunction to stop the sale. The requirements are fairly specific. The borrower has to file a complaint in the state court where the property is located. They have to file that and give notice of an injunction hearing at least 5 days prior to the scheduled foreclosure sale date. And then to obtain the injunction, they bear the burden of proving either that they have actually paid this loan and so the foreclosure process is improper, or there is some sort of fraud or misconduct by the lender that the court should investigate further and so should not let the stay move forward because they will be irreparably harmed. Some courts interpret that more strictly than others. Some courts are more generous with granting those injunctions, but it's a fairly high bar to meet. So the other more obvious route of stopping the foreclosure is to just file bankruptcy, which is what most folks do. But the benefit of the non-judicial foreclosure is they file bankruptcy at the front end. So after we get the file, it may be 60 days out from us getting the file to foreclose, they file bankruptcy. Whereas when you have to go through the judicial foreclosure process, they can file bankruptcy at any point in time in the process. And generally, it's going to be the evening before the master commissioner sale after you've already went through a year-long foreclosure process. And then they file their bankruptcy, maybe you get stay relief, and then you have to go through the steps of getting the sale reset. So overall, it really speeds up the process. I think it does increase the number of Chapter 13 bankruptcies in particular that we see. Nashville has a lot of Chapter 13 bankruptcies. I think Memphis is the capital of Chapter 13 bankruptcies. It also may be one of the foreclosure capitals. So it does, I think, encourage a resolution more quickly once you've gotten in the process. Folks often ask, may I take a deed in lieu of foreclosure? We can do deeds in lieu of foreclosure, assuming that title work is appropriate and you don't need to foreclose in order to extinguish subordinate liens. But we rarely recommend it, absent some exceptional circumstances, because we can foreclose so quickly that we are able to foreclose, potentially preserve your deficiency, and not be dependent on a borrower to sign a document that you have to negotiate with the borrower and then run the risk that the borrower pulls out at the last minute and refuses to sign the deed in lieu of foreclosure. So, we often do what we call friendly foreclosures, which is maybe we've reached a settlement with the borrower agrees they're not going to contest the foreclosure, and we reach some sort of settlement on it, but we actually go through the notice procedure rather than the deed in lieu process. May I postpone the foreclosure sale? Yes. Tennessee recently passed a statute to clarify the common law rule that foreclosure sales can be postponed for up to a year without republishing in the newspaper, which is a substantial expense related to the foreclosure sale. So as long as the new sale date is within 1 year of the original foreclosure date, the postponement is a date and time certain, and the postponement is announced at the original sale date and location, then you only have to send a letter out saying what the new sale date is to all of the parties on the original notice, as opposed to putting it in the newspaper again. So your deed of trust is in second position should you foreclose, and the answer is generally not. In the foreclosure sale process, if you are a second lien holder, the proceeds do not go upstream. So you foreclose the property and take ownership of the property subject to the first deed of trust, which of course triggers the due on sale clause in the first deed of trust. So unless you are prepared to immediately make arrangements with the first lien holder to pay them off, you likely won't want to foreclose a second deed of trust. Maybe the first lien is very small and your second's very large, so maybe it makes sense. But in a lot of circumstances, there's going to be some due diligence involved to try to find out exactly how much is owed on that first deed of trust before you foreclose and undertake the obligation to pay somebody else's debts in order to get clear title to the property. How much should I credit bid? This is an area of hot debate right now. In 2010, Tennessee passed a statute that codified the common law, which was, in order to preserve a deficiency, the bid must be the fair market value of the property at the time of the foreclosure sale. And that term is a loaded gun, because what is fair market value? You're talking about a fire sale on the courthouse steps of a property that nobody can go inside and look at before the foreclosure sale, sort of a pig in a poke, we don't know what we're buying. And so there's no bright line rule. Kentucky has its 67% rule, which cuts the equity, and most of the time I think is upheld as far as the value. And there's been a recent Tennessee Court of Appeals case that found that 80% of the appraised value was sufficient under the circumstances, but that the court was going to refrain from setting 80% as a bright line rule. I'm currently litigating a case where the bank bid 100% of the appraised value, and the foreclosure sale or the deficiency that we're seeking against the guarantors is being challenged because they don't think our appraisal was correct, and they think the property was worth a lot more, so they shouldn't have to pay their deficiency, even though we bid 100% of the appraised value. So we generally recommend a bid somewhere between 80 and 100%, just depending on the circumstances. But if you're going to pursue a deficiency against the borrowers, we're recommending bids at the higher end of that spectrum to try to cut off as much of that litigation as possible. Maybe next year I can give an update on what happens with the 100% case. The other issue with respect to deficiency judgments is the same statute imposed a 2-year statute of limitations on seeking a deficiency judgment. So you foreclose next month on a piece of property. You don't know if your guarantors have any assets or not. You haven't really decided if you want to spend the time and money to get a deficiency judgment, which requires filing a complaint and going to court just like any note or guarantee litigation. You only have 2 years to decide. So after that 2 years, it's a full defense to any obligation on the guarantee. You can file the suit on the note and guarantee before the foreclosure sale as one method of avoiding the fair market value argument. But a lot of times you want to see what the property will bring before you decide whether to waste the time and money pursuing a deficiency judgment. So it's definitely creating some unique issues. Another common question, do taxes take priority? Like most states, only the real estate taxes take priority over a properly perfected deed of trust. But the tax liens from the state of Tennessee and the IRS get special treatment. You have to give them special notices, and they can retain a right of redemption. We do allow receivers to be appointed. Just having a provision in a deed of trust that allows for the appointment of a receiver as a contractual obligation, sometimes that is enforced and sometimes it's not. Most often courts are requiring a showing of something more than just the contractual right. They're requiring some sort of showing of a danger or loss by a further delay, that the rents are being used for other purposes other than paying the debt, that there's some sort of waste or fraud going on at the property. And so most of the time, if your loan's in default, you're able to show some of these elements, but it is a matter that is contested. And again, you have to file a complaint to get the receiver. And because we can foreclose so quickly, unless there's a specific reason you need the receiver to preserve the value of the property, most often you can get in and foreclose before you could even get a receiver appointed. If you have an operating business that you need to maintain the business operations in order to preserve the value of the property, that might be reason to bring somebody in. If there's some sort of harm to going on to your collateral, you may want to get in and do that and find out what's going on at the property before you foreclose. If the borrower won't let you get your inspections completed, that may be a reason to get a receiver appointed. But in most cases, we can foreclose so quickly, it doesn't make a lot of sense without a specific business purpose. Receivership sales are an interesting issue that has had more popularity lately, and whether a court-appointed receiver can sell the property and avoid the foreclosure process altogether. And we are seeing more courts allow this to happen, allow us to avoid foreclosure, and allow the receiver to line up a private sale rather than putting it out to auction. Also allows the bank to remain outside the chain of title, which is sometimes appreciated for some of our more difficult properties. The harder part, I think, other than getting the court to approve, because if nobody's contesting it, most of the time the court would sign off on it, is making sure you have a title company lined up who will ensure the sale through a receivership. And we have been having some luck with some title companies, less luck with others. So it's definitely a challenge. But if you have a property that for one reason or another you can't take into inventory, that's an option we can explore. One more note on a different statute, and then I'll let our Georgia folks go. There's a statute called the Tennessee Collection Services Act, and it is an act that requires all collection services businesses to register with the state of Tennessee. The judicial interpretation of a collection service is an entity which purchases due accounts and then attempts to collect on those accounts. So if you're collecting your own bank loans, not a collection service. If you purchase another bank's portfolio, potentially if you merged with another bank, if you take assignments or purchases of notes, perhaps you purchase notes from the FDIC and take that portfolio. Those could all be considered collection services. Attorneys are accepted, banks are not. And so we are seeing this raised as a challenge when notes are purchased, and particularly when lenders are purchasing defaulted notes or portfolios that contain defaulted notes, and they are being deemed a collection service. And one of the popular topics in litigation is if they have not registered with the state, potentially they are not entitled to bring a lawsuit to collect the debt because they are a collection service. You don't want to be it. The obligations of registering as a collection service are fairly strenuous, and it can get very expensive as they charge per office and per licensed collector. There is legislation pending that would specifically accept banks from being a collection service, so we're going to cross our fingers that the bank lobby is successful in getting that passed so that banks are specifically accepted. But in the meantime, we're seeing this as a challenge in a lot of note and guarantee suits where the note is not with the original lender. So that's our unique Tennessee law for the day.